Hello, this is Mark Smerschel. I'm Vice President and co-presenter for BeneFLEX HR Resources. Today, this is an introduction to 3 separate educational webinars, and whether you're joining us because you're interested in Part 1, Understanding the FMLA Employer Requirements, Part 2, How to Identify and Investigate FMLA Abuse, or 3, focusing on ERISA and Department of Labor audits, you're going to be excited because all 3 of these webinars were approved by SHRM and HRCI and the Department of Insurance for professional credit at the seminar we presented a while back. So when we're talking about BeneFLEX, we want to make sure you understand we're a third-party administrator that focuses on pre-tax accounts. We were started 23 years ago by Jim Smerschel of Smerschel and Tallor, and we work on these accounts with many clients in the Midwest and on both coasts. Most recently, we added services due to ACA. We added the reporting. And in January of 2017, the Qualified Small Employer HRA was brought forward as a way for small employers who don't offer insurance to reimburse their employees' individual health care coverage costs through an HRA. Now, when we're talking about BeneFLEX, we wouldn't do anything without our partners that we work with. And these are some of our clients that are very strong partners when it comes to benefits, and they drive a lot of the services that we bring forward because they share their needs with us. And it's the BeneFLEX team that is here to help you when you call in, and all team members, when you reach BeneFLEX, will help you with your plans, or they can help get you to the person that knows about their plans, because each one is certified by the Employers Council on Flexible Compensation. But the other part of BeneFLEX that you don't see is the partners behind the scene. Our Bene card, or the Red Bene, has been around for 20 years and has been meeting the needs of flex programs for all of our clients. Well, that partnership is very dependent upon a second partnership, which is the financial institutions behind the scene. The HIPAA high tech and the protection that we bring forward from our IT partnership, and the customer service and IVR that we have available. The programs that run the software, the Flex, the HRA, TMA, all of those are a partnership with WEX Healthcare, and that works with Allegis, which makes the card work at the pharmacies. And then lastly, we have Smerschel Tallor, our sister company, who is a very strong partnership with the audits and controls they have in place to make sure that your accounts and your plans are kept in compliance. So why are we here today? Our partners, meaning our clients, were very good about bringing back the surveys that we sent out, asking what were some areas they needed help in. And 74% of you very strongly identified FMLA as something that you wanted additional discussion or you wanted additional help with in terms of the resources. So to do that, we had to go out and find a new partner. And BASIC is that new partner, because BASIC is a top 25 HR technology winner in 2017. So what that means is by finding a strong partner on the technology side, BeneFLEX can take that technology and be a conduit for all of our existing clients and new clients that need FMLA or ERISA, because by having a large amount of volume going through, we can get you a package price and a better deal. And you already have a strong relationship with BeneFLEX, so why start a new one when you can work with a trusted partner? So in speaking of trusted partners, I want to introduce Joe Aitchison, who is going to present the 2 presentations on FMLA and the 1 presentation on ERISA. Joe is a human resource professionalist with over 25 years in the business. He is recognized as a leader in that management profession, and he has obtained a lifetime certification as a senior professional in human resource management by SHRM. He is a certified senior professional and HR specialist by Healthcare Reform Centers and Policy Institute. Here's Joe.
You know what ERISA stands for? Employee Retirement Income Security Act, right? That's totally not correct. It stands for every ridiculous idea since Adam is under ERISA. And I truly mean it. If sometimes, I don't know if you're like me, if you have trouble sleeping, take this 2,300 page document to bed with you, and I guarantee you will not make it through 5 pages. It loops. Every one of those regulations that are in there, and those sites and sections, codes, they talk in a language that circles. And by the time you're done reading it, it really makes it difficult. But we're going to try to make it simple. We're going to talk about changing times but not compliance. I'll start with some good news. For those of you that are not in California, for those that you are in California for a lot of reasons, I'm sorry. But for other reasons, when it comes to looking at ERISA and welfare benefit plans and claims and complaints, we see more coming out of the state of California than we do any other state in the country. It doesn't mean that we don't see them out of other states, but we see the majority of them coming out of the California area. We're going to talk about what are some of the ERISA requirements. God, this sounds dry already, doesn't it? I'm going to fix it after lunch, I guarantee it. So, we're going to take a look at some plan compliance. We're going to look at the Department of Labor because they're the ones, once again, through the Employee Benefit Security Administration, EBSA, but DOL controls everybody's work life. And so they also control ERISA as well. ERISA covers the 401k plans, your pension plans, also your welfare benefit programs, okay? And there's certain rules and requirements. We're going to look at that. We're also going to look at an audit and some best practice stuff. So what does ERISA cover? Employee benefit plans sponsored by governmental employees and, again, church employees are exempt from ERISA requirements. So if you're a government entity or a church, you don't have to have ERISA documents in place. However, if you read the ERISA regulations, it doesn't cover churches and governmental entities. It does state that churches and governmental entities on page 1862, I think, do have to have ERISA-like documents in place to show who's covered and what eligibility rights and all that sort of stuff is there for their employees that work for a governmental or church entity. Okay? When we look at plans that are covered, as I mentioned, it's your welfare benefit plans and your pension plans. Our focus today is not on the pension plan stuff. We'll leave that to Jim and his team, the CPAs. They talk about that stuff. That's way over my head. We're going to look at the welfare benefit stuff. Here's the plans, and I apologize, it's pretty small on your screens, but we're looking at medical, prescription drug, dental, vision, fully or self-insured. ERISA says that a group health plan that has 2 or more covered individuals is covered under the ERISA, and it's also supposed to have what's called a summary plan description or an SPD. Now, you get arguments back and forth that when you take a look at what's called the SBC, Summary of Benefit Coverage, that's the SPD, Summary Plan Description. No, it's not. For a small employer, I'm sorry about these acronyms. It's not my fault. It's like ERISA. I have other names that I can't tell you what SPD and, you know. And if you think of the S, we'll let it go at that. So we'll let that one go right there. But when we look at the summary plan description for a small employer, the summary, the SBC, Summary of Benefit Coverage, you can take some documents and then you can surround that Summary of Benefit Coverage. Here's the benefits that we're giving, like here's a health benefit and the dental. And oh, by the way, you have to work 30 hours and then you get this stuff and then this is what it covers. You know, that document that you get that BeneFLEX and their team provide to you, and you share that, then you can take that and say, here's your eligible employees, you know, here's the eligibility and all of that. You can surround it with some language, some COBRA language and all that. And so sometimes you can look at that as a pretend SPD and the DOL will accept it. Okay, it's not clean, ain't pretty, but if you needed to pull it together, you can kind of fake it. And then by faking it, they'll give you a pass, most likely. Most of the time, they're coming after you, we'll talk about it when we get to the audit side, because of an employee complaint of sorts. And I'll talk about why those are. But it covers that. EAPs are not covered, employee assistance plans are not, but short-term disability, life AD&D, on-site medical clinics, group travel, wellness programs, and yes, executive physicals for those that had that question. No, I'm kidding. What plans are not subject to ERISA? Thank you for asking. Plans, HSAs, health savings accounts. It's a bank account, right? It's not a health benefit program. So that's the reason why it's not covered under ERISA. An HRA, a health reimbursement arrangement, is reimbursing for a health benefit, as an example, or a welfare benefit. That is an ERISA plan. Okay. Fringe benefits like adoption, tuition, adoption plans, tuition reimbursements, stuff like that. Voluntary plans, I get this a lot. With some small employers, what they do is they bring in a voluntary plan and they say this is part of our group health benefit offering to employees, this voluntary plan. They support it and promote it as a group benefit, even though it's 100% paid for by the employee. If you take that type of position, excuse me, it is covered under ERISA because you're marketing it to your employees as a group welfare benefit plan, even though they're paying for it. Okay? If you say we do have a voluntary vision program, or we have this other voluntary type of program, and if you want to join, that's fine. We'll give you the information and we'll payroll deduct that and pay that over to the voluntary benefit plan provider, and that's pretty much what you do during open enrollment. That is not an ERISA plan. You don't need to put it in your, you don't need to create an SPD or a wrap SPD for that. And we'll talk about that, those definitions. Telemed, God, you stole my thunder on that question. When we take a look at telemed plans, if it's a referral only, hello, I think I have the flu, I have a temperature of 104 degrees. Yes, you do. Sounds like you do have the flu, it's in your area. Go get some over-the-counter stuff and you should be okay in a couple days. That's it, that's all they do. Then that is not considered a health benefit because they're not prescribing, they're not diagnosing, they're just talking to you about that condition. Maybe you need to go see your health care provider, something like that. So that doesn't count under telemed. If it offers medical care or treatment, that's number one, then the answer is yes. If it offers prescription, yes. And it offers diagnosis with no treatment, the answer is no. Yeah, you've got the flu. Now it's kind of interesting, they added another codicil or another point underneath this, and it's kind of, because now they're actually doing exams over the phone. I don't know if you have a camera on your computer, they can literally do exams and talk you through that. I don't know, personally, I wouldn't want to be talking to a stranger and saying, okay, take off your shirt. You know, I'm not sure I'm there yet. That would scare anybody, but I'm not going there, I'm sorry. But the answer is there are programs that are out there. And the other part of it is that if it's paid by the group health plan, or those prescriptions are covered under the prescription drug plan, or if it's a medical diagnosis that's covered by your group health plan through that telemed program, the answer is yes, that's an ERISA plan and it's a health benefit. Here, you know, the millennials and the Gen Zs, the Gen Xs and all those folks are coming up. Everything is going this direction, and the telemed programs that are being linked to healthcare benefits are growing by leaps and bounds. So if you're not familiar with them, I bet you will be in the next couple of years because they're really, really growing. And the Gen Xs or the Gen Ys, young folks and their kids, the Gen Zs that are coming up, the babies with the computers and the cell phones at the age of 6 months that are talking to you now. They're texting you. They're not even talking to their parents. I got a vivid imagination. I can't go there. But anyway, they're looking for on-demand and they want it now. They don't want to wait. And so you're going to see a lot of telemed diagnostics that are going to be happening more and more. And it's going to reduce the cost of health care. We can talk a lot about those kinds of things. So when we look at plan document requirements, a RAP SPD versus a SPD versus what some people call a RAP, which is a bundling, things like that, it gets a little confusing. If you have a RAP SPD, a RAP SPD is where you have a life AD&D, as an example, a short-term disability plan, a medical plan, and a dental plan, you know, typical. You have all of those. ERISA says you need to have a summary plan description for those group welfare benefit plans. So the option is that you can write a summary plan description for all of those plans separate, and a lot of that information is redundant. It's the same language, but you have it for your medical, you have it for your life AD&D, all those different ones. Or years ago someone said, can't we just write one to cover it all? And the answer is yes. So you should be able to look in your welfare benefit plan file, you know, your contracts that you have, and it will always say, if you have one, summary plan description or RAP summary plan description, okay? It may also say sometimes plan document and RAP summary plan description, or simply summary plan, RAP document, summary plan description. Welfare benefit program summary plan description for life AD&D for ABC company. Okay. The plan document and the SPD or RAP SPD that covers them all, there can be one and the same document, or they can be two separate documents. ERISA, you'll hear attorneys go back and forth, which is better. 6 will be over here saying that they should be separate documents. 6 over here say no, they can be together. So, and ERISA says, kind of sort of make up your own mind. A plan document is a legal document that is written in somewhat legal terminology, okay? The RAP SPD is a document, or that SPD is written in common language, typically at an 8th grade level, so that your workforce can understand it. Okay, I'm not saying that they're not smart, please don't think that. It just meets that criteria as being something that is understandable to the workforce. And so it can be one and the same. If it's a plan document, wrap SPD for ABC welfare benefit plan, then you wrap it all the way around all of your documents. Confusing a little bit, or am I okay so far? Okay. Okay. The plan document, it names the fiduciaries, the controlling, the management, and also the board of directors where information where they're approving the welfare benefit plan for the company, you know, all of that legal stuff. And I talked about the fact that you can, I want to stop here a second and explain that this is a very important document. And we've had clients all the way across the country that didn't have their WRAP SPD in place or their summary plan description for their medical plan or their other stuff. They'll call us or call BeneFLEX and they'll say, we don't have this, you know, we've got a problem, they're coming in. Or one of our past employees filed a complaint with the state insurance agency. They're asking for all this kind of information. We don't have it, what do we do? Okay. Now, not like the FMLA, it's not necessarily that bad, excuse the vernacular, an oh crap moment. It still is a bad thing. You need to have these documents. But the interesting thing is that typically they're wanting that employer to have this information in place, but they're not going to hurt you badly if you don't. Very rarely have I seen them come out with substantial fines or penalties because you didn't have them. They want you to put them in place, and unless you do something that's really bad, you're going to be kind of okay if you put them in there and you didn't harm somebody. If you harm somebody, and I'll explain how you do that, then at that point they're going to go after you for that harm. Okay. But because you don't have your plan documents, if you look at buying companies and stuff like that, mergers and acquisitions, if you ever do that sort of stuff, go to the question, whoever's responsible, just ask them to take a look at their welfare benefit plan SPDs. And if all of that falls in place, if they did that correctly, then bet your bottom dollar that all of their other compliance stuff is going to fall right in line, because if they did that well, you know what else they've done well is all that other stuff. So it's a pretty cool tool that you can use if you do that sort of stuff. Summary of material modifications. Let's say, and this happens today all the time, an SMM, if you have a group health benefit and they're charging $1,200 a month for your family plan, I'll just use that as an example. And our friends at BeneFLEX and the team get together, and agents and brokers and all come together and say, oh crap, this is going to be $2,000 now per employee. You guys are going to just lose it, right? You're going to totally lose it. Well, we can't stay here. We got to go somewhere else. Can't you get us something that's closer to $1,200? I mean, this is what you do to keep those costs down. When you do that, do you have to do a new SPD? The answer is maybe not, or a new WRAP SPD. Maybe you don't if the material aspects of that summary plan or that health and welfare, if you change from one carrier to another carrier, you went from that renewal of $2,000 down to a renewal of $1,500, but you just changed the provider and maybe something here changed a little bit, then you can do a SMM, summary of material modification. It must be provided to each participant within 210 days after the end of the plan year when there is material changes made in the plan. Hi everybody, we changed from ABC Insurance Company to XYZ Insurance Company. 210 days. Everything else pretty much remains the same. They're getting that SPC, Summary of Benefit Coverage paper, during open enrollment that says pretty much the same stuff. Okay. If you do make a material reduction in benefits, well, in order to get that $1,500 premium rather than the $2,000, we had to change the copay amounts for the prescription drug. So instead of being 5, 10, 15, 25, 45, 65, to some people, that's a pretty material change, right? Especially if they're only making, $15 or less an hour. That's a big deal. And so then you still can do that under an SMM because you're still offering that prescription drug, just a little bit different fee structure. And then in doing that, what you do is that you have to get it to them no later than 60 days. So it depends. If you're just changing like providers, not a big deal. If you're making a material change, then you have a notice that you have to provide them. Okay. Elimination or reduction of benefits, deductible or co-pays changes, reduction in like an HMO service, any type of pre-authorization or out-of-network kind of stuff like that. That's big. How do you distribute this SPD or SMM? Now again, it's not necessarily the largest thing that's on their mind, but it's an important thing. Do you give it to the entire employee benefit or your entire employee population? You give it to those that are covered. If you have a wrap summary plan description that picks up short-term disability, life AD&D, maybe family, life as well that's attached to that, okay? Your health benefits and your dental, if you don't take our health, you can't get our dental and all that sort of stuff like that. Well, what happens if you do a wrap, then in order to, most of your employees, all full-time, get short-term disability and they get life and AD&D, right? When you do a wrap document and that's included, then you got to give them that wrap document because it covers their eligibility information regarding those benefits. So this is some of the things that you need to think about whether a wrap is appropriate. Because you may only, let's say you have 60 employees, and of the 60, maybe only 20 take the health care benefit offering that you provide. But all 60 are full-time, and then they all get the life AD&D and the STD, and you wrapped it. Does that make sense? So you guys got to make those kinds of decisions, okay? Can you distribute these electronically? There's certain requirements that are there. A lot of employers say, well, we put it on our intranet, and then we've got a kiosk that's in our lunchroom, and they can sit down and look at the stuff during their lunch break. That should be good enough, and the answer is no, it's not. Because the employer is controlling that, they don't have access to that information, so there's supposed to be an acknowledgement process if you provide this to employees via electronically. Or if you're in I'll call it a service technology where your entire workforce is on business email, then what you can do is put that on your internet, do a notice to them because you already know that they're technically savvy, right? And so by providing that, but also you need to have a statement that indicates that they have opportunity to have a printed copy by going to Human Resources or something like that as well. I want to talk a little bit about 5500s. 5500 is a form that needs to be filled out when, on a welfare benefit plan, when you have pensions and 401ks, you have to do that regardless of the size of that group because you're talking about financial stuff and investment where you have employees' money for retirement, very important. When you look at it from a 5500 for a welfare benefit plan, first and foremost, if you have to file one, that plan will always begin with a 501, 502, 515, 500 number, always. And I'll explain why in a minute. And then the other part is that you only have to do a 5500 if you have 100 or more employees or participants on that group health plan as an example. Employers will fail on their 5500s because they only look at their health benefits, but like in my example, let's just say they have 150 employees. They make an offer of health benefits to their employees. They have 80 individuals that have coverage, 80 individual employees that have coverage, okay? It doesn't meet that 100 requirement, so do they need to do a 5500 for that welfare benefit plan? The answer is no, but they have short-term disability, and they also have life AD&D where they have 150 or 125 covered. And so they need to do 5500s for those plans because there's over 100 individuals that are covered, okay? Very important from that standpoint. Do this for, if you have over 100 or you know an employer that has over 100 employees, go to the internet and just ask Google, put in ABC Company 5500 lookup, or just put in lookup 5500s. It'll take you to a FOIA, Freedom of Information site, which will take you into that 5500 lookup, and you can see if ABC Company has filed their 5500s for each year for their welfare benefit or their their pension or their 401k or whatever they have, which employers are really, really good at doing. And then you can also take a look at the 5500s that were filed for their welfare benefit plans over here. Let's see, they did one in 2012, maybe 2015, maybe 2016, 2017. There may be some gaps in there, or they don't exist at all. If you can do that, don't you think the feds can do that too? Just a thought. And the reason why I bring that up is because it's a low-hanging fruit. The answer to that is that do they really take advantage of that low-hanging fruit and look at it? Not really. We don't. What we'll typically see is that if there's a misfiling on a 5500, we'll get questions on that misfiling. But they typically will work with you. If you have, let's say you're a new HR person and the employer never had more than 7,500 on their health benefit plan, or excuse me, 75 on their health benefit plan, but they have 150 employees on their life and short-term disability. They never did a 5,500. That penalty could be as much as $1,100 for late 5,500 fee, or the penalty for late filing under the Delinquent Filer Voluntary Compliance Program is $10 per day up to a maximum of $2,000. But that's kind of like per year. And then here is what we're looking at as the maximum penalty. So that employer that never ever filed anything for the last 10 years, they call it Schedule A's that go along with that. I won't go into that level of detail. It's kind of like an oh crap moment because they didn't do what they were supposed to do, right? And so how do you fix that? And we fix these all the time, is that we go under what's called this Delinquent Filer Voluntary Compliance Program. For that $4,000, it doesn't really matter the number of years. You can file it all. For that $4,000, you write a check, or you pay it online to the feds, and then you're done with it, and that gets you up to date. The important thing to note is that once you do this one time, there's no freebie after that. You've used your one time. And so they'll come back at you later if you screw it up. And so be very, very careful and use it. Now, when do they take a look at the stuff? Oh, and I want to say this too. If you have a health benefit, two health benefits, you've got a HRA, high deductible health reimbursement arrangement, and then you have a conventional plan that's a little bit more costly. Under the HRA, you have 60 participants. And under the conventional program, the 80-20, if they even exist, they still do. There's still 90-10s out there, if you believe that. They're not affordable for most of us. That's a Cadillac plan. But anyway, if you have one of those and you have 30 people under that, 75 plus 30, 105, you're over 100. You got to file a 5500 because you have your welfare medical program has two, and so you got to look at it from that standpoint. Now, I'll tell you why all this stuff is important as we work through once we get up to that point. When the important thing to remember with the RAP SPD and the SMMs and all this sort of stuff like that, I'm going back to that side of it, is it's only the employee that you have to give this information. Fully insured, self-insured, it doesn't matter. The employee is the one that gets this stuff. Am I killing you with this stuff yet? I know it's kind of dry, but you're doing great. You really are so far. Because it's going to get interesting here. When we take a look at the model notices and other requirements, you've got the HIPAA model, notice of privacy practice, summary of benefits and coverage at SPC, the notice of exchange availability, the ACA stuff, which was kind of set aside, notice of ACA grandfathered status. In other words, you haven't changed your plan in a number of years. I can't remember the exact date anymore, but the reality is most of you have changed your plans unless it's a union contract. Your child health insurance program, the CHIP, all that sort of stuff. And this is where it's going to start to get interesting. Investigations, complaints, directed investigations. Here's where stuff starts to happen. Why do they come in and take a look at you? Because they're not really there. They don't really much care. It's the low-hanging fruit on the 5500. They don't go there typically. It's not what they want to do, but they want to make sure that a couple things happen. This happens a lot with small employers. And if you're a small employer, you may know exactly what I'm talking about. You are collecting money from the employees for their premium copays, right? $100 a month, $200, $250 to pay for that health benefit. That's their money they're collecting. You're putting it into your general account, which is a no-no, but let's just say that that's what you're doing because that's what most employers do. You're sticking it into your general account. You're supposed to pull it out of the general account and do what with it? Use it to pay the monthly group health benefit premium, right? Things are a little tight this month. Your accounts receivable is growing, but your cash is shrinking. You got a $50,000, $75,000, $250,000 health benefit bill that you need to pay. And my line of credit is where? I got to wait a week. And so, if your spouse is like my spouse, God, I love her, thank God she's not here. She goes to get her prescription drug filled, and they say, I'm sorry, ma'am, your insurance has been canceled. You know who she calls? She calls me. And you know what she says? Hey, Joe. Yeah? Hi, hon. What did you do now? What? What did you do? I didn't do anything. Well, I went to get my prescription filled, and guess what? It's canceled. What did you do? I don't know. So now you got a spouse that can't get the prescriptions because of anything that I did? No. Am I going to skate that one? No, because she knows me all too well. But setting that one aside too, the employer screwed up with whose money? By God, she says to me, we pay $250 a month for this. It's $1,200, but we're paying $250 a month for this health insurance, and I don't have it, and I can't get little Joey's insurance or prescription. You fix this. If you don't, I'm going to. Hello, State Insurance Agency. How are you? What's up? Well, ABC company just canceled my insurance, and my husband said that he didn't do it. Okay. Oh, really? You see how I'm starting to paint a picture? And so who do they screw up with? The individual with their money. And that's how these dominoes. Now, are they going to come back on you because you did it one time? The answer is no, typically they don't. They're going to start to build. An employer goes bankrupt. They're holding what? Employee funds for what? Health benefits, right? They look at that, especially large employers. These are the kinds of things that kick it off. I wanted to put this in here under the ERISA side from the standpoint that all of the Department of Labor and all of the EEOC follow pretty much the same stuff. The DOL doesn't have to issue an initial letter. They can just show up on your doorstep if they wanted to. But typically what they'll do is they'll, for under ERISA, they'll issue an initial letter with a document request that goes with that. They're going to do maybe some on-site interviews, and then after they take a look at all the stuff that they want to, then they're going to do a closing letter, and then maybe a voluntary compliance. When a Department of Labor investigator comes in, and God bless them, they'll pretty much follow this. There's 3 columns. Yes, you did it. You kind of sort of did it, that middle one. And no, you didn't do it. Those are the 3 major columns. And over here they have a grade column. It says, you fixed it. Okay, so that's what they're looking at. Now, when it gets to the ERISA side of it, they want to see, yes, you did it, or maybe you kind of sort of did it, or you fixed it. And they're going to know, so you never want to misrepresent to that, and you never want to be mean to these folks when they come in. I encourage you to always work with someone that knows how to do this stuff, or have this stuff in place so you don't have to worry about it, okay? And so work with someone that knows, like your friends at BeneFLEX. They know this stuff, honestly. And so that's what they're going to do. They can make restitutions and make it whole. Now again, they're not after you. They're not aggressive with this. There's other bigger fish to fry, so they're not going to really want to hurt you. They just want to make sure that you're doing it correctly. If Joe is paying you as an employer that $250 a month, they want to make damn sure that you're going to pay that to the insurance company timely, and they want to make sure that all of that $250 goes to the insurance company. Not 200, not 180. That's what they're after. And they're going to want to fix it. They're going to take a look at the general ledgers. They're going to do all that sort of stuff like that. They're going to also want to make sure that that employee is made whole. After my wife is done with me when her prescription drug wasn't filled in time, I don't think I'll ever be whole again. No, I'm kidding. But you see where I'm going. Now there has to be restitution for her and for everybody that had to do what? Instead of pay that $25 copay that ended up paying $150 or $250 or whatever that amount was. That has to be made whole. And also, if you do things really, really bad, there's criminal sanctions. The DOL and Office of Inspector General, they have an audit guide if you're curious and can't sleep, and you can go take a look at that too. So there's the employers notified by letter, the examiner requests plan records, preliminary meeting, they do the on-site audit, the resolution, and a closing letter is issued. This is an older one that I wanted to use, but just as an example, this is an actual redacted Department of Labor Employee Benefit Security Administration letter that a couple years back one of our employers got. Hi, Joe. What'd you do? No one ever says hi. What do you do? Well, we got this letter, and what are we supposed to do? Okay. Tell me what the letter says. I already know what it says, just to get them to relax and say, what do we do? What do we do? We go through it. Well, this is what they're asking for. Can you produce this? You ready? Can you provide, remember I said that plan document is separate from the SPD, but if it says plan document, SPD, it's the same. You can give them one document for both. So do you have a plan document? Do you have your SPD? All contracts with insurance companies for provisions of health benefits. If you don't, call your broker, call your friends at BeneFLEX. They'll go crazy, but they'll get it for you. Self-insured, all contracts for claims processing, which would be your contract with BeneFLEX for the flexible benefit program, the HRA, whatever you have in place. If you don't have it, it should be in your benefit file, right? And you go, well, the person that had that file quit 2 years ago. I don't know where the hell it is at. You're going to have to do what? Recreate it. And when they say 5,500, if you say, what's that? That could be a problem too, just to let you know. Okay. And so from that standpoint, documents which describes the responsibility, all the plan rules, Newborn Act, all the written descriptions for benefits mandated by Women's Health, copy of the grandfathered records for the terms of plans for the past 3 years. They love that 3 years. You can sometimes talk that down. Sample of written notices describing enrollment opportunities, age 26. Copy of the choice of providers, contract or agreement with any independent review organizations. Insurance premium billing statements for the examination period. You see, they're looking at how much was the bill and how much were the co-pays at that point, doing a general ledger audit from that standpoint. Billing statements, and they're also going to ask for a copy of your company handbook. Why do they want that? Because God love you all, and if you haven't updated your handbook since about 2011 or 10, employees are eligible for group health plan benefits if they work blank hours or more, 40, right? That's what we all had in the olden days. What does your summary of benefit coverage say? 30, right? And so if you have a mismatch, I want you to think about this. Who gets that SBC, summary of benefit coverage? Only those individuals that sign up for the health benefits? Who gets your handbook? Now, Joe that's trying to save a few bucks and put it into a separate account takes my handbook home and say, "Hun, you know, I only work 30 hours. I can't get health benefits because it says 40 here, so I don't have it." And then I put the other extra money, that $200 a month, I put it in my secret account. No, I'm kidding. Telling all my stories here, but
Better hope we don't catch your wife.
oh God, yeah. Like I said, she lives to kill me every day. But what I'm saying is that you see what's happening because I feel as though I may not be qualified. Of course I know I can get benefits at 30 hours, but because I didn't do it and it says in my handbook and I get into a car wreck and I didn't have insurance, what's the first thing out of my mouth? Think about it. My handbook says, what? 40 hours. I didn't get this other thing. Now, who could be potentially liable for that variation? And you know what happens next? Because that complaint's going to end up with the state insurance exchange or your lawyer or their lawyers, and God knows everybody else's lawyers that are going to make a couple bucks. They're going to ask you for what? Your summary plan description, which shows your eligibility for what? Health care benefits at what age? See? This is where I love you all, I really do. And this is why I'm 25 and look at me now. Because it's not you, I don't know you all that well and I'm very timid. No, it's the other 15,000 that are like you that make it difficult. Okay, and so that's the kind of stuff that they're looking for. And I know we ended a little earlier. You guys deserve a break, but I'm going to turn it over for questions now as far as ERISA goes. Number one is that if you don't have it, please don't lose any sleep tonight over it. Please don't. But wait a couple months and then start losing some sleep because you really should have it. Okay, you really, really should. And if you ever do get a complaint, or you're going to be sold and another company comes in and they want to know how really special and great you are, you have all of this documentation, they're going to think you do everything else really well too. I'm just being facetious, but the answer is you really need to have this documentation. The 5500s is a bigger deal because your CFO is going to frown on HR for not doing it. There's a breakdown in linkage between those CPA guys over here and HR on a variety of different things. We'll start with unemployment and all of that, the way that that's done, but that's a different story. But when we look at it from this side on the 5500s, they are so good at doing 5500s for the pension plans and the 401ks and the 403bs and stuff like that, but they're not worth a crap when it comes to the, sorry, he's not even paying attention, when it comes to the 5500s for the welfare benefit programs.
So, and they're required 100 and above?
Yeah, there's what's called a Schedule A, and a Schedule A comes from the insurance company that tells you how many people are covered under your plan year. If you have 100 or more, you should get what's called a Schedule A, either directly from the insurance company provider or from your agent or broker. Does 100 minimum also apply to retirement plans? The answer is no, it does not. Any type of retirement program has to report because you're functioning as a financial fiduciary, and this goes to Jim more than it does to me from that standpoint, because I don't play in that water. That's, hell, I got enough with benefits, let alone finance. Leave it to the experts. Other questions? Yes, ma'am. What is their limited involvement when it comes to an HSA from the Department of Labor, Employee Benefits Security Administration? They don't touch HSAs because health savings accounts is a bank account. If the employer is contributing to it, does it have to be included in the wrap document? The answer is it can be. Now I'm gonna hedge my statement here because I haven't looked at that in a long time and I can't remember. But I'm going to say that it's not necessary, but I could be shot. If there was an attorney here, an ERISA attorney, I would ask them to respond to that question because I don't recall. I'm sorry. Good question. You caught me. God. I'll find out for you. And I'll let Mark know. Yes, ma'am. Okay, if you pay fringe benefits for union employees, are you paying the fringe benefits to the employee themselves or for the employee under a contract with a healthcare, or are you paying it to the union local or to the union?
Yeah, paying it to the local.
Okay, thank you for that clarification. For union plans, if you're paying to the local, that's their problem. If you're paying to an insurance carrier, even if it is union employees, and a lot of times you'll see contracts written where the health benefit or welfare benefit plan for a union employee is being paid by the company to an insurance carrier, part of the deal, then in that situation the answer is yes, that has to be in your SPD. Anything that goes to the union, they have to write their own plan documents. Good question, thank you. Other questions? That's a great question. If you're going to do an electronic distribution, you can, if you have email addresses for all of your employees, whether it be a work or a personal email, then number one is to send them an email requesting that they allow you to provide information, welfare benefit plan information to them. And then you wait to get a response. And then what the investigators will look for is a list of who you sent that email to and the response that they sent you back. And then when you attach that document to send out to them electronically, then put a read receipt on it. You know, you can do that off of your email. Or if you're posting it onto an intranet site, then attach an acknowledgement that they have clicked and read it. You know, I am acknowledging that I've received this or reviewed this, and then once they've ticked on that, that becomes your record. That's my recommendation, and that will meet their requirement. Because at that point, if you miss one or two, like I said, they're not going to be too upset with you because they're not there to hurt you from that standpoint. They're going to look at that individual case-by-case basis, unless it's a bankruptcy or a sale or something like that for that group protection. You'll be okay. So that's a best practice when it comes to that. The other is, and when you post it on the intranet, if you do that and you know your employees have access because you are a technology company, they all have email addresses, keep a list of who you sent that email out to, and that will suffice as well. Those are the best practices when it comes to electronic distribution. I encourage you to do that if you can, because otherwise you're printing volumes of information, printing and printing and printing and printing. And then, oh crap, it changed, and then you're going to print and print and print and print and print again. So it gets to be a little tough. The question is, it is a good practice for you to keep a signature page that in the employee file that acknowledges that the employee has read it and understands it. Or read it, I shouldn't say understands it. That's a different statement. It's not hurtful to do that. Is it necessary? No. I think it's a good idea, though. If you're not doing it, I wouldn't worry so much about it, as long as you make sure that it has to be given to those that are covered, and if you can evidence that you're providing it during the open enrollment period, a lot of you will print that stuff and give it to them, or on a new hire, like with your COBRA notification. If you've got a process in place that you can evidence that this is what you do as a process, it's like all your other company processes that you have in place. This is our process and we follow it, and you can evidence it. When you take out a new employee packet and you flap it open in front of an investigator, as an example, all this stuff is in there, and you have 6 of these or 8 of these already pre-prepared. That's your process. They're going to be fine with that, typically. Typically. Good question. Thank you. I would say, just as a point of information, generally speaking, when it comes to ERISA complaints, we probably see across the country maybe a dozen most per year on ERISA, what we'll call, and then that's when an investigator is actually coming in. That's why it's not, don't lose sleep over it, but it's an important thing. So it's not that high of an issue. When it becomes an issue is when the state insurance agency is there, or you get that, it's more important when you get that private lawyer, you know, that plaintiff attorney that's contacting you and wants your documentation. That's where it's a setup. And so, because they already know to ask for the same kind of stuff. I mean, it's public information. They'll run right down it and looking for your flaws or your gaps. Yeah, a quadro or along that line. And so, is it necessary to provide it through the front of the court system or through the legal system to an identified party? Was the question, and the answer is yes, because it's through the court system. And the court system is looking for documentation as far as eligibility as well as participation. The reason why I say that is because if the state has a CHIPS, child health insurance program in place, that if the benefit coverage, health benefit coverage is not available through the employer or through that employee, then there might be Medicaid or another type of health benefit program that's available for that child. Not to the child, but to the court that requests it, yes. Yeah, because they look at the macro rather than the micro. Yes. Good question. Only if it's requested, not in all situations, because you won't know what the circumstances that are surrounding that relationship is, so only if it's requested, upon request. Thank you for the clarification.